Hello, everyone, and welcome back to Statutes and Stethoscopes. Today's guest is a powerhouse trial attorney from Northeast Pennsylvania with over 20 years of experience. He began his career at the Anzalone Law Office, a firm founded by his father, and in 2025 became a founding partner of Anzalone Doyle, which is now a 10-attorney litigation firm. He focuses exclusively on personal injury, trucking litigation, nursing home abuse, medical malpractice, and product liability. He has secured numerous verdicts and settlements over $1 million and several exceeding $2 million. He's board certified in civil trial law by the National Board of Trial Advocacy, a distinction earned by just 3% of attorneys nationwide, and by the American Board of Trial Advocates, having tried more than 20 cases to verdict. His work has been featured in Pennsylvania Law Weekly, AAJ's Trial Magazine, and recognized among top PA verdicts in multiple years. He's been named a top 10 attorney in trucking and nursing home litigation by the National Trial Lawyers, a frequent lecturer on trial strategy, medical malpractice, and nursing home litigation. He is a past chair of PAJ's Nursing Home Division and past president of the Northeast PA Trial Lawyers. Outside of the courtroom, he's a proud husband to Mary and father of 2 daughters, Nora and May. And when he's not fighting for justice, you might just catch him singing and playing the guitar in his band. Please welcome Jamie Anzalone to Statutes and Stethoscopes.
Thanks, Tracy. Looking forward to digging in deep on some exciting topics here.
Yes, absolutely. So in today's episode, we're going to cover when to take a case, how to challenge arbitration clauses, and why the lack of a Department of Health citation might just be the tip of the negligence iceberg. But hang tight to the end because we're saving the big one for last. How do you calculate damages when your client has outlived their life expectancy? And the answer just might surprise you. So Jamie, why nursing home work?
Well, Tracy, it's pretty funny that you asked this today and we're on this podcast because I literally just got out of a nursing home mediation. And it's funny, I was telling a story in this nursing home mediation because the group we were going against in this case, and of course won't name them, was one of the groups I first went against 10 years ago when we first started doing nursing home. And apparently, this is only the second claim this particular nursing home has ever had against it. The first being the one I settled against them 10 years ago, and the amount that I've learned in the last 10 years is incredible. And I think why nursing home work then is honestly the same answer as to why nursing home work today. And the answer is pretty simple. First, this is a very forgotten about part of our population, elderly folks in nursing homes. And, there's a lot of folks that are in there that their kids that were taking care of them undergo tremendous guilt in having to put their mom or dad in a nursing home. It's something that's crippling to them at times. And then only to learn that something went wrong and they really do blame themselves. And then, this population really can't fight for themselves. I mean, they can't even, they can't take care of themselves at home. Their kids can't even take care of them. And now here they are they're asking these facilities to take care of them. And look, by and large, there's a lot of great care out there. People who are CNAs and nurses and nutritionists and dietitians at these places, they are saintly in certain moments and certain places. But unfortunately, we see some really bad care. And especially when you see families that, unfortunately don't go in and see the moms and dads enough, you kind of see even worse care. And then it comes to fruition that something really bad happened, whether it be a bed sore because they weren't being turned and repositioned, whether they fell because the fall intervention guidelines weren't followed, whatever it may be. You look at that case and a lot of people would say, well, they're 90 years old, 95 years old. They have outlived their life expectancy. Why even take a case like this? The damages aren't there. We started taking a lot of this work 10 years ago or so and creating damages and bringing these people's stories to life because they are forgotten about. And the more and more you focus group cases like this and try these cases to verdict, you see that jurors and the public, they haven't forgotten about this part of our population. In fact, they sympathize greatly with them. And you start coming to light with all these terrible things that are happening. And then you're giving life to people that are not able to protect themselves. And now you get this very rewarding feeling that you're taking cases that a lot of attorneys don't want to take, and you're breathing life into these people and to these families that were forgotten about and not taken care of. And I just settled this case just 10 minutes ago. And honestly, I have the same rewarding feeling from this for this 95-year-old woman who passed away in a nursing home as I did for the 90-year-old woman that I represented 10 years ago against that same nursing home. I'm happy that feeling hasn't left me. And so it's still rewarding. I remember that case I settled 10 years ago, having this wonderful kind of hug and good feeling and good moment with them when the case was resolved. It was on behalf of their mom. It was a daughter. And today it was two daughters that were 69 and 71. And it was that same rewarding feeling. They said, well, you went to bat for us when no one else really would. And that still feels good to this day. And I know we're doing good work on behalf of these people to hold nursing homes accountable.
So that was your first nursing home case then? And that feeling really is what kind of fostered you to want to keep going?
Yeah, because you're dealing with typically very good clients who are doing the responsible thing by getting their family member into a nursing home. That's not an easy choice, right? I mean, that's not just like dropping your dog off at the kennel. This is a very, very hard decision. And it's the right decision. Most people don't have the financial needs to say, oh, we'll just get home health care. We'll get the best care, bring them into the house. Mom and dad can live with that. That's not reality. The reality is they care for their parents in their own homes for years. And then it comes a point in time they say, well, I can't do this anymore. And this is a really, really hard decision. And you could hear these people tell their stories about, we went to 10 different nursing homes and we finally picked one. And then that one betrayed us.
Yeah.
And then to see those cases through to the end, jury verdict or settlement is still a very rewarding feeling. And it's the right thing to do.
And I think a lot of the people we talk to, sometimes we get the calls as well. It's the families are angry because there's dignity issues there too in a lot of these cases. They feel like their loved one is not being taken care of and they're violated in a way.
And then sometimes I think everybody focuses on, well, what's the actionable part of these cases? Unfortunately, you're not going to always bring a claim because someone's diaper wasn't changed one day. As angry as that would make you, or because their food was cold, or because they had a scratch on their arm that wasn't there the day before. Unfortunately, those kind of single item issues they really don't have enough damages to justify bringing a claim. But when you do have the big event, the fall, with a broken bone, or you have the bed sore that it takes months to heal, or go septic or whatever, if you have that one kind of really bad area, there's no reason why when you're bringing that claim, you can't throw everything else in, because it's showing a pattern of betrayal and neglect. And that's where we see that a lot. A lot of times in our complaints, not only will we talk about the big event that went wrong, but we talk about the general bedside manner and all of the issues that person was having in connection with the big event.
So how do you decide whether or not to take a case then?
Again, this is a Pennsylvania podcast, I'm assuming. So we have to deal with Pennsylvania law. And when you're dealing with nursing home cases for people that are, not working anymore, right? They're 80 years old, 90 years old. Even those that are in their 70s are not working. They're at the nursing home for a reason. They're disabled in some manner. You don't have any cases that have loss of wage. And other than, some, past medical bills, right? With a Medicare lien or a Medicaid lien, it's a lot of times rare that you even have a future medical bill claim because unfortunately the person's passed away, or they've already gotten the care they're going to need and they don't really need much more. They're just living with this horrible injury. So obviously to take a case, we have to calculate the damages and to figure out what they are. And the best way to look at it is just to quickly rehash the PA law. And that is that, if we have a living plaintiff, someone who fell in a nursing home, fractured their hip, and they're still living, well, that person's usually not coming to see us. It's usually their son or their daughter, or someone has the power of attorney for them. And how we're calculating damages is we're getting an idea of what we think their non-economic damages are. So that person who's still living with the broken bone and the hardware and implanted or whatever it may be, their pain and suffering, their mental anguish, their loss of enjoyment of whatever life they have left in the nursing home, their disfigurement, their scarring. And as we know in Pennsylvania, these are non-economic damages that a jury has to come up with a figure on. We can't suggest the number. But if you do enough of this work, you kind of get a sense on what the marketplace value of that is and what the cases can settle for. If we have a case involving a death, we have to figure out, was the death caused by the negligence? If it was caused by the negligence, then you have a wrongful death recovery for whichever family members are alive, whether it be a spouse or their children. Most times they're grown children. So you have to figure out, what those claims may be worth for the children's grief loss of the parent or the spouse's grief loss of the spouse. So that's the wrongful death recovery. But then even if the death wasn't caused by the negligence, you have the survival part of the case. So the pain and suffering and those non-economic damages we talked about earlier, what those damages may be worth in the person's survival claim, which is that time period between the injury, so a fall in this case, and the time of death. And that could be 2 years. It could be, a month, and it may not have caused the death, but it's a time period that there's pain and suffering. So we do enough of it. We know what the cases are valued at typically. And that's kind of a good start as to calculating your damages. The unknown in all these cases, and this is why you can't take a nursing home case and just settle it like you would maybe a car crash case with State Farm or Progressive before you have to file a lawsuit. In nursing home work, once you start getting in and doing the discovery, you start figuring out, is there a roadway or a pathway to punitive damage? And that gets you into a whole nother stratosphere on the damage value of a case like that. And sometimes when we get the cases originally, we know that there's going to be punitives. It's just a question of how bad the conduct is that we find. So I think that's kind of the general outline of the cases. So I'm not saying you need to have all those, but you have to have categories that amount to something that's, going to make sense for the client, because you can't do a nursing home case with at least a nursing expert, right? So, that's going to be upfront cost. There's going to be a lien of some sort with Medicare or Medicaid. So, very difficult to look at a case and say, oh, well, case value is $25,000 or $50,000. That makes sense for you to take that, son or daughter. Sometimes just financially, economically, it doesn't. So there has to be some value, not crazy substantial value, but significant value to justify moving forward with these cases.
And earlier you said you sometimes had to get creative with the damages. What's the most creative you have ever had to get with the damages? What would that look like?
You have a client. Here comes the case to you. You have a client who gets transferred by ambulance. Not really a nursing home case, but I think this is applicable. You have a client that's transferred by ambulance, and the client is going to the hospital for a UTI. But during the transfer, they don't strap her foot in and she fractures her femur. And then in the hospital, she passes away 3 days later and she's 96. Okay. I would say a lot of lawyers, not most, but a lot of lawyers will look at that and say, where are we going here? There's hardly any survival damages whatsoever, because the pain and suffering is days. Wrongful death, has maybe one or two children and they're, in their 70s, right? So how do you get creative to try to build that case? And the standard against an ambulance company is gross negligence. So again, how you get creative is building the story, right? Meeting the family, finding out, what was mom like right before she got this UTI and had to go to the hospital? What kind of shows did you guys watch? What did you do that week? Tell us about that week leading up to it. And you'll learn that they were watching Wheel of Fortune. They went to dinner. They did this, that, and the other thing. That would be no different than somebody who's doing that in their 60s. And you say, well, what kind of grief loss do you have? Your mom's 96. I mean, you were so lucky to have her for all those years. Well, actually, it gets harder to lose somebody when they're 96 because it's a part of your life. This woman lived with her daughter. It was a part of their life for so long, a mainstay. And that woman was healthy. Nothing was wrong with her. And then she had a little infection that required to go to the hospital. But on her way there, she gets this fracture, which was the result of gross negligence because they didn't strap her in correctly. And now we say to the ambulance company, this was a major, major blow to this family. And yeah, she outlived her life expectancy, but they did everything together every single day of the week. And so the creativity in a case like that it's not even being creative. It's just doing good work and getting to know your client. Find out everything they did in the week before the death and everything they did in the month before the death. How close is the relationship? And then you can start building your damage against that ambulance company for someone who's 96 years old, right? Outlived their life expectancy by a lot. And you now have a wrongful death recovery for a 70-year-old and a survival damage for 2 days. And I won't tell you what we settled that case for, but I could promise you that was a lot more than someone who just got hit in a, kind of a whiplash car accident. It was a significant number, but it takes being creative and getting to know your clients and building the cases.
No, absolutely. And I think that's really the art of the practice of law. And I think that kind of really makes you stand out from, the attorneys that out there that aren't doing that, that don't get to know their clients in that way. So you mentioned use of experts. So let's segue into that. What types of expert do you typically use, and what's most important for you when you're looking for a medical expert for the maybe medical people out there that are looking to become experts? What's some things they need to think about when they're trying to become an expert? What's important to you as a trial lawyer when you're
Okay.
hiring an expert?
So I think that, again, I would say the reason nursing home work may be more appealing than people think it is two reasons. One, I do a lot of truck work, and I consider nursing home work to be a truck case without the wheels. The reason for that is the nursing home industry is heavily, heavily regulated by the Fed, right? There's all sorts of F tags that talk about the minimum standards that are required for care. And there's lots of them. There's requirements on staffing. There's requirements on the way the activities of daily living are tracked. There's requirements on documentation. I mean, a nursing home chart is overwhelming to someone who doesn't do it. But once you do a lot of it, you can look through it very quickly and figure out where the problems are with that nursing home. Just like if you're a truck attorney and you do a lot of truck work, you could look through the employment application and the logging and the electronic downloads and everything to figure out where the violations. So that's the first thing I love about nursing home work is that heavy regulation that you can make the cases very rule-based, right? And that's why a lot of trucking cases, when you dig into it, are appealable to jurors because they say, well, this guy's supposed to be abiding by this set of rules, which is different than car drivers, and he's breaking them. Nursing homes are supposed to be abiding by this set of rules that's heavily regulated, and they're breaking them. A little different than a medical malpractice case where you have a doctor who goes in and there's a standard of care, but so much of it is in the doctor's judgment. The way a nursing home can be run is not in judgment. It is what it is. That's such a ridiculous expression, but it is. There's no, oh, well, we should only have to turn them, once every 5 hours. No, the standard, it is regulated that when this person has this type of bed sore, it's every 2 hours, period, right? Or they need to have their meals at this time, or they need to be helped with, assistance according to this reg. I mean, it's very regulated, very rule-based. So with that, you can get into nursing home work, and it's a little overwhelming because there's a lot of that stuff. But once you learn it, it's not that overwhelming. The second part about nursing home work that's appealing is, and I don't want anybody to take this the wrong way, but the costs are not like they are in medical malpractice cases. If you are suing a neurosurgeon or a neurologist or a hospital system, you have to be ready with an army. You need neurologists, you need board certified neurosurgeons, and every one of those experts, and as they should be, because they're just at another level, are so expensive. And you have to, because the defense is going to do the same thing. In the nursing home world, it's a little bit more streamlined, and your cases typically are defended on the defense side and on the plaintiff side by nurses. And nurses are so helpful, but they aren't the same cost as a neurosurgeon in a medical malpractice. They just aren't. And so and I hate to say this, and I don't want to be paying more. They probably should be, because their reports are so much more detailed than I get sometimes in medical malpractice cases. They're so on top of their regulations. They know the game so well as to what nursing homes are supposed to be doing and not doing. But in any event, it's just not that same cost. They don't carry that same cost with them. So always a nursing expert, and it depends obviously on what type of case you have, how specialized within the nursing field you want to get. In a bed sore case, I'm never handling one unless I have a wound care certified nurse. Matter of fact, we have a nurse on staff in our office who is wound care certified. I couldn't use her, of course, to testify, but I need that kind of knowledge on somebody to be running a bed sore case. But so, bed sore case, definitely a wound care certified nurse. But any other regular cases, medication mix-ups, assaults on patients, fall cases, a nurse, a registered nurse, who of course has a good background in the nursing home field, which is different. It's just different than, say, in the hospital system field. Someone who's been a director of nursing, someone who has been an administrator, perhaps, someone who just knows that field inside and out. So that's always one of the experts I'd get. The other expert I would get, especially if we're having to prove that the fall or the injury caused the death, I always want to have a geriatrician to talk about the cause of death. I don't think the geriatrician needs to have any crazy specialties in neurosurgery if you had a brain injury, or in orthopedics if you have an orthopedic injury leading to death. A good geriatrician, internist, someone who's been a hospitalist, who's signed tons of death certificates, that's kind of the second expert. That's really what I would typically go with. If we get into a staffing case where we think that they're understaffed, we think that they're really cheating the system, I'm probably going to want to have some type of expert that has managed nursing homes as an administrator or has been in the administration part of things, because you're going to need someone to comment if you're going into that area, which is very regulation heavy, very administration heavy. You need an expert that may not even be a nurse. It's probably going to be someone like a hospital administrator, a nursing home administrator.
Sure. And I think that's a very good point because that's a lot of, I think there's a lot of confusion in that the administrative versus the director of nursing, that one is a nurse and one is an administrator, not necessarily both the same. Sorry, my voice today. So, how about the Department of Health? If they don't go in and cite the nursing home, is there still possibility for the case, or is that case out the window?
Yeah, one thing I would tell people listening to this who aren't lawyers, who've had things happen to their family, if something bad happens that doesn't smell right, report it to the Department of Health, like immediately. They take this stuff very, very seriously. And you'll get a case manager. They may do an unannounced visit at the facility, and you can get some closure on whether or not you think something's wrong. And you can get some evidence back that you can use in your own, kind of just in your own life. You got the lawsuit for the minute. From the lawyering perspective, and I've had a lot of people refer me cases who have done this, and this is actually how I learned to do it myself. You get a call from a client who says, my mom just fell the other day. I don't like what happened. It doesn't seem right. And maybe we're not signing them up right away because we just don't know if there's anything. Maybe we're going to set a client meeting in a week or whatever. You tell that client, go to the Department of Health and report what you're seeing. Because in your own head, you think, well, just as a human being, you should report what you saw so that someone else doesn't have something bad happen to them. But if this case turns into a lawsuit and there's significant damage and there's negligence, that is a piece of evidence that you can use in the case. It may not necessarily get into court. A judge may not allow it, but it's something we can use in our case at some point as against the facility. So, of course, positive Department of Health findings of fault and violations and them sanctioning the nursing home is super helpful because, you can just go right to the nursing home and say, look, you were cited. Did you fight it? Did you try to, argue it? Because they can appeal. They could appeal every violation they get. No, we didn't. Why didn't you? And if you thought you were so right, why didn't you? So you could kind of screw around with that and get some points with that. But the bigger question, and that's just the way you phrased it, was what happens if the DOH finds nothing was wrong?
Right.
We got a lot of these cases, right, where the clients say, my mom fell and, nobody was around and she didn't have a bed alarm and, she broke her hip, and we reported it to the Department of Health. Department of Health does an unannounced visit and they find that there's nothing worth citing the nursing home for. Well, keep in mind that the Department of Health is not a nursing expert. They're a regulatory body that comes in to see if something was really wrong and whether or not a violation or a sanction is necessary. Kind of a little bit of a higher standard. Well, our job in law is to prove by the preponderance of the evidence that the standard of care was breached. The Department of Health is not looking at a case in the same lens or through the same lens. So don't get discouraged because the Department of Health didn't find anything. Do your own research and figure out, was the fall preventable? Well, you may have an inkling on your own if it is or not, but you need an expert anyway to file the case. So take a look at everything you get. Look at the care plan. Look at what the baseline is of that patient that's going in there and figure out with your nurse whether or not everything was done properly. I've had lots of cases where our nurses that are experts have found that there is no way they should have done what they've done. And it's a breach of the standard of care because this woman's care plan said that she was supposed to have these fall preventions, but with that fall risk score that she should have had a bed alarm, period. That's the standard. The Department of Health may miss that. They don't do the type of review that we're going to do with our experts.
Mhm.
So, if you're ever going to reject a case just because the DOH found that nothing was worth sanctioning, I think that you'd be making a big mistake.
Okay. And you have mentioned before, I guess I have the question. So the nursing homes are supposed to report these things to the Department of Health if they're a certain level, right? And so,
Right.
and then there's certain evidence that is or is not allowed, right, in court or a trial, or at certain points in the litigation, I guess, certain things are protected that they're not allowed in or out. And so maybe you're just speaking to that a little bit about, what things are maybe protected because they're doing them as remedial measures or whatever. I mean, is that
Yep.
a thing
Uh,
that comes up at times?
Yes, actually, we tried a case to verdict about 2 years ago, and this was a huge point in the case. So, had a lady who was being transferred from a wheelchair to a shower chair, and in the process of doing so, she fell and broke her hip. The the CNA who was transferring her had her rest her hands on the lip of a tub that did not have a grab bar. So, right after this incident happened, way before we got involved, because the case got referred to us almost a year after the accident, the Department of Health comes in and cites the nursing home for not having a grab bar. They pay a fine and they end up putting a grab bar in. So, if you got rid of the Department of Health, for just this example, in the law, we would call what the nursing home did by putting the grab bar in post-fall a subsequent remedial measure. And typically, except for a few exceptions, and this wouldn't be one of them in this case, that's not allowed in the court. So if we were trying the case, it is not admissible that the nursing home made a remedial measure of putting a grab bar in. That's the first thing. The fact that they were cited by the Department of Health is not relevant because the Department of Health is no different than a police officer citing them for speeding. It's not different standards of law that the jury needs to follow, different burdens of proof that we need to carry to show that somebody was negligent. So there would be a fear that if the jury heard the Department of Health cited them for it, that would be prejudicial, and the jury would then say, oh, well, they must be negligent. Because just because they didn't have the grab bar, just because they were cited for it, and because they put it in after, that doesn't mean they were negligent in the first place for not having it. So here is these two great pieces of evidence that we have that the judge says, you're not getting that in. You are not getting it in because you're not getting, it's just because the DOH cited them for it. That's prejudicial. The jury has to make their own decision whether or not it's negligent to have not had a grab bar. And then also they put this in after the fall, so it's a subsequent remedial measure. And if you let all that kind of stuff in a trial, then companies may not want to make these subsequent remedial measures, and it would discourage potential safety. So that's why that rule is in place. So in this case, how do you get around that? Well, you get an expert who says what is right, and that is them not having the grab bar is a violation of Pennsylvania code, blah, 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 blah. Period, end of story. It is negligent. So you prove it in different ways, right? But it's annoying because these Department of Health findings, more often than not, are not coming in because of the fear that the jury would say, oh, well, the Department of Health cited them, they must be negligent.
Yeah, absolutely. So I'd love to talk now. Go ahead.
But what I'll say is those Department of Health findings are very helpful because you can use them in your depositions to talk to the nurse and say, do you remember speaking to the Department of Health? It says here that you did this on this date, but you just told me 10 minutes ago that you did something else. How do you explain that? So you can use that for impeaching these witnesses when they try to change their story when they told the Department of Health something else.
See, I love how creative your mind is with using all these things. You end up getting them in the end.
Which
leads me to my favorite thing to hear you speak on, and these arbitration agreements and the amazing work that you and your firm have done with, the work around getting these things, sort of thrown out, I guess. So I'd love to hear you speak on that a little bit. Are they enforceable? Ins and outs of these arbitration agreements, how you work around them.
Okay. So, and it's crazy that this is actually bleeding into the health system now with hospitals arbitration agreements. But let's kind of give a description on what's going on here in the nursing home industry first. So first, before I start this topic, I have to give tremendous kudos to my partner, Kelly Saravallo, who has kind of made it her mission in this office to beat as many arbitration clauses in nursing home admission packets as possible. And she's done a great job of it. And we've really hammered this. And the reason we do it is because let's go back to why nursing homes even have them in the first place. So typically you get admitted to a nursing home. Whoever gets you in there, it's usually your son or your daughter, right? They're given a packet of information that is about this thick. Within it is an admission agreement regarding arbitration. And it says on the top, this is not a precondition to admission. And then they tell you that if you were to sue the nursing home for whatever reason, for personal injury damages, you have to go to arbitration as opposed to being able to have your case heard in front of a jury. Now, it's sandwiched in the entire in the huge admission packet, which is like 100 pages. By law, they can't make it a precondition to admission. So technically, someone can say, I'm not signing that, and they have to let you in the nursing home. If you're a Medicare facility and you get Medicare dollars, you must put that heading on the top. not a precondition to admission. I don't know a single client of mine who has signed one of these who said anyone ever even told them that it wasn't a precondition to admission or that they saw that on the top of the packet. And do you know why they never see it? Because, and I know this because we've taken the deposition of people who administer these agreements to our clients, they show it to them on an iPad and they just keep scrolling through. And they say, okay, well, here's the admission packet. Here's this, sign this, sign this.
Sign.
So no one ever sees that hard paperwork. And a lot of times on the arbitration agreements, there's a part of the paperwork that says you have a right to have this looked at by a lawyer. You can take a look at it with them. You don't need to give us an answer right away. We encourage you to do this, that, and the other thing. And we've come to learn that none of that is ever really told to the people that are admitting their parents. So just on a human level, we know this is going on, and that's why we think these agreements are garbage. But that's really not enough to show that they're not enforceable. Typically, you have to show that the person who is signing the arbitration agreement doesn't have the standing to bind the person who they're admitting. So a lot of times we'll see power of attorneys do the signing. Well, a lot of power of attorney agreements say this doesn't kick in until I am unable to make decisions for myself. So we've had a lot of nursing home patients or clients who had no problems with competency whatsoever upon admission, and their son or their daughter just signs them in. Well, we've routinely beat that by saying that power of attorney was not triggered. So there was no authority to bind mom or dad because they were mentally competent. So that's happened a lot. A lot of other times, sons or daughters, and it's totally human nature, totally understandable. They're not thinking about all this stuff. They're thinking about getting mom into a nursing home because she just fractured her hip and she was at a hospital and now she has nowhere to go and we can't take care of her. Sign whatever. Son or daughter signs mom or dad in, and they're not even a power of attorney. They have zero authority. And they're not doing anything wrong themselves, but they're just trying to get the ball moving. So we would ask the nursing home after we file a lawsuit to present to us the arbitration agreement that was signed. And a lot of times it's signed by someone who has absolutely zero authority to bind them. And then on the flip side of it, sometimes the patient who is completely incompetent, right, where they do BIMS scores on them and they're, at 3 or 2 or 4, which is, as you know, severely cognitively impaired. And they're the ones who are signing the admission agreement themselves. So they're not competent to understand the agreement. So those are just a few examples of how you beat them. And we've beaten a lot of them. And there's a good reason why you want to beat them. Juries don't really like nursing homes. They don't like the system. It's been corporatized so much with outside facilities and corporations taking over these places one by one. And a lot of them have, a lot of jurors have had really bad experiences with nursing homes. I'm sure there's a lot of great ones, but there's a lot of bad ones. And the nursing homes know that. And that's why they want to get as many arbitration agreements signed as possible, because now if you're a lawyer and you're looking at this case and you say, all right, well, the person who fell is in their 90s, damages may be limited. Oh, and by the way, there's also an arbitration agreement. So instead of having 12 of our, this person's peers, someone who could identify with the plaintiff's daughter or son to render this award one day, well, they're out of the picture. Now you're going to have to try your case in front of a mutually agreed upon judge or lawyer of someone who is just unfortunately not going to have the same empathy that jurors do in these cases. So
Right.
Very, very important. And it's bleeding over into the hospital system. There's been a couple cases recently where people have had to sign agreements to say, if you're going to get medical treatment here, sign this agreement. It's an arbitration agreement. They don't explain it. And now they're locked in. And there was 1 or 2 courts that have upheld that. And so imagine, you're being the victim of medical malpractice at an outpatient facility or you're at a hospital and you signed your right away to a potential jury trial. So you got to be really careful as to what's out there and what kind of rights you're giving up.
So that's why I think this is such an important topic, such an important issue for people to be aware of. And I think one of the questions would be, what would you recommend for somebody that's going into a hospital then that has this agreement presented to them? They don't know what they're signing. And are they allowed to just say, I'm refusing to sign this, and they still have to be cared for? Would that be the same for the hospital and the nursing home? And also, the other question popped into my head, I think that people would want to know is, why is not knowing what you signed not enough? If they're scanning through and you don't even get to see the disclosures, what's the point of the disclosure? If you don't get to see it, you're not being informed and you're signing this stuff. Why is that not enough in the court's eyes to get these things thrown out?
I guess the only way I can say to kind of hammer this home is to tell all of our viewers who may admit their parents into a nursing home is to ask the nursing home administrator or the admissions person that they're with, is there an arbitration agreement here? If so, I won't be signing it. And by law, that they cannot deny you admission, period. End of story. Again, with you not being able to see the agreements is like, and I say as good as you should because they're ripping through it on an iPad. The only way to try to ensure that you're not giving up your parents' rights to a jury trial is to say, hey, I know I'm signing a bunch of stuff. I want my parent to get in here. But if there's an arbitration agreement, I am not signing it. On the flip side with the hospital systems, I'm not really sure where that appears in the documents because it's so new. And I think, you would have to maybe take the same approach. I don't know if that's what we're going to have to do now from now on. I mean, they tell you what you're signing. Usually they'll say on the little keypad, okay, here's the HIPAA form. Here's what you need to sign to have this released to your family doctor. And I think you ask, is there an arbitration agreement here I'm signing? Because if there is, I'm not signing it. So I think that's the best I can do. That's the best
And
we can tell.
if they refuse care based on that, then what? What do they do?
There's really, the law is that if you're a Medicare facility, and every facility is, I mean, unless it's privately owned and you're only accepting private money, which just doesn't happen anymore. They have to have that language that it's not a precondition to admission.
Have you found the nursing home starting to get smarter with these things at all, with these arbitration agreements? Like, because you think you had said either if they're mentally not capable or the children are not power of attorney, have they started to look for it? And have you noticed anything with that as you've been bringing these cases now?
No, I haven't really seen that. All I can say is think of the amount of people that are admitted into nursing homes. Think about the amount of lawsuits that are not brought. And think about the amount of attorneys that don't fight the arbitration agreements. If a few slip through, if a few really good nursing home lawyers throughout the state of, let's just say, Pennsylvania, are wise enough to go after these agreements, it's such a small percentage that the nursing homes are going to say, we don't need to do anything to change this. I mean, so what? A couple of them beat us on the arbitration agreement. All I could say is I haven't seen any change in how they administer it for the last 10 years. I mean, and we've been doing this. We've been doing nursing home work at least 10 years, and I haven't seen any change. The only change that I've seen is the Medicare guideline that says, this is not a precondition to admission. Early on, 10 years ago, they didn't have that language up top. So no, I don't see them getting smarter. I don't see them getting smarter. I just see them getting quicker, and just ripping through these agreements with people and getting them to sign them without them having a single idea of what it is that they're signing.
Okay. And so now I think we've kind of prepped our listeners. How do you calculate those damages when your folks that you're representing are nearing the end of their life?
Well, I kind of alluded to it a little bit before. And again, I think it goes back to this creativity of the story, right? So for instance, today, this case I settled, this woman fell in a nursing home, fractured her hip, and died a month later. She was 95 years young, grossly had outlived her life expectancy. So you take that case and you say, well, what can you possibly do with this? I mean, the family's lucky to have had her, for all these years. So what's the wrongful death damage on that? And if you look through the medical records of a 95-year-old, there's going to be so many comorbidities, so many different medical conditions that the defense is going to be able to say, with or without this fall, this woman was going to die in the next couple of months. Okay, so several key things that you need to do to get around that to say, I don't really care what the age is, right? We can still build the damages when they're past their life expectancy. So first, I talked about a geriatrician. So not only does your expert geriatrician need to relate that the fall caused the death, but they also need to give some idea of what the potential life expectancy from that point forward was without the fall. And a good geriatrician who sees and treats geriatric patients into their 90s has the ability to do that. So there's a lot of different key factors, looking at their blood work. You're going to have their family doctor records. You're going to be able to see, what the major diagnoses were. Was there anything in there that, while they all may have fatal and terminal, consequences one day, is there anything in there to suggest that that was happening at the time of the fall? The other thing is, and this happened in our case today, that was the defense's play. They said, look she fell at our facility, but that didn't cause her to die because she died a month later. She had many other things that were going to cause her. I said, okay, well, let's look at your records that show you say she had great rehab potential. You were sending her to physical therapy multiple times a week. Well, why didn't you just put her on hospice? If she's so bad Like you say, she was going to die and she didn't fall. Why isn't she in hospice? Which means she has 6 months or less to live. You know why? Because two things are happening. Either A, she wasn't ready to die, and you guys are just kind of talking out of both sides of your mouth, or B, you're just billing her family. You're billing Medicare, and you say she's so bad. And if you really believe that, then why the hell are you sending her to physical therapy? Just to crank the bills up. So
Right.
both of those answers are good for your case. However, I don't even need it to be answered. I would say to a jury, I'd say they tell you she was on death's door. And this fall, even though we dropped her, did not cause her to die. I say, okay, well, then why wasn't she on hospice? They're the ones who can make that decision because
Right.
she wasn't ready to die. Or why were they sending her to therapy 3 times a week, getting her better if she's on death's door? If she really was on death's door, then what they're doing is they're billing and it's fraudulent. So that's how you can kind of get them coming and going when the argument is there's no damage here. This woman outlived her life. And with that, I'll say it again. The argument is always, you lost your mom at 96. What a blessing. And now you're asking this jury to award you grief damages for losing her at that age. If God was going to give her another year, one more year, 365 days of not being able to talk to your mother, who is such a major part of your life, is a damage. And it is a grief damage. It's not the same grief for everybody. But if you had a daughter that was with her every day of her life, every day at the nursing home, to not have her for 365 more days is a damage. And let a jury come up with it. The right
Oh,
jurors may
absolutely.
see that be a very big deal. The wrong jurors may say, well, you're on a money grab. But if your client is a good client, a good juror is they're not going to penalize them that way. So that's kind of my theory on outliving life expectancy and why these cases, if someone's 95, it still has a value. Our oldest client that we ever settled a case for was 96 years old. And it was a good number. It was the ambulance case. I'm dying to get a case resolved for someone who was 100. The centurion hasn't happened yet. I did look at a case for someone who was 102 who had a bed sore, but there was no negligence that caused it. I think we can do it. And, it just to show that the life expectancy means nothing. A human life is a human life, period.
Well, it's
And
absolutely
one
true.
is,
That one thing we can't get any more of is time, right? We cannot get our time back. We can get almost anything else, but the time, yeah, sure.
that's right. There's a good line. If I had more money, I'd buy more time.
Absolutely. That is the truth. Look at Walt Disney, right?
That's right.
Well, look at, I have an uncle who's 103 and he's had some hospital misadventures. So let's hope he's not going to be your next client.
Oh, yeah.
So I'd like to just talk a little bit now. I mean, all of this was such great, wonderful information as always, Jamie. Thank you. But let's talk a little bit about you. Let's get to know you a little bit. Tell us where you grew up, life as a child.
Well, I grew up, as did all of my partners, right here in the Wyoming Valley, Northeast PA. And that means a lot because, we represent people from this community, and we are very proud to say that we have invested in this community over the years and continue to represent people from this area. There's a lot of people who, go into different communities and they're not even from the state, right? And we're very proud to be here and from here and doing the work that we do here.
Yeah. And your father was an attorney, right?
Yep, my dad. So my dad started our firm in the early 90s. I came to start here in 2006. So not quite 20 years, but it'll be here before I know it.
Yeah.
And we were my dad, myself, and another attorney. We were a 3-attorney firm, and we've built a team since I've been here. My dad hasn't really handled cases for a few years, and we've built a team that I am very, very proud of. My partner, Pat Doyle, Kelly Siraval, my sister's out in Colorado, and we've hired a number of other great attorneys, Joe Price Jr., Steve Kopko, Aaron Decker, guys that just are running 100 miles an hour, handling a lot of cases and doing it well. I'm just so happy and proud of the team that we've built here. Kind of took a great thing that my dad started and I believe took it to the next level. So
Yes.
that's
Talk about legacy, right?
yeah, that's how
Absolutely.
we're doing.
So your sister's also an attorney. How about any other brothers, sisters? Is she your only sister?
So my sister's 13 months younger than me. She followed me everywhere. I went to Lafayette College. I played football there. She came and she dove there. Then I went to Dickinson Law School. She followed me there. We lived together there. And then I came and joined my dad's practice and she followed me here. But then when she got here, she said, all right, I'm done following. I want something different. And she moved up to Colorado. And that was almost 15 years ago. And she created her own practice out there. Still, it's Anzalone Law Offices out there. It's not Anzalone Doyle, but she's very much affiliated with us and a partner of ours. And she built this incredible practice out there. And she is a great trial lawyer and has tried a bunch of cases. The verdict's gotten several million and multi-million-dollar awards. Yeah, she's just got an athlete's mind. I mean, she's never gives up, never stops working, doesn't like to get told no very often, and wins a lot of cases. She's great.
She's your only sibling?
I'm sorry. And then you were asking about her other siblings. My brother is a forensic psychologist. He'll be 50 in August. And he started our county's mental health court. So for people that have, certain mental illnesses and have been convicted of a certain level of crime, they'll qualify for the court. And it's saved the county millions of dollars and people who would be repeat offenders going to jail. And he's, helped them through the system and they graduate through his court. And so I'm very, very proud of the work that he's done.
So you miss your sister when she left then, your shadow?
Yeah, I do, but she's really happy. But she needed to fly, and she did a great job. And I'm happy with the life and identity she's created out there, and it's fantastic. But she comes back. We see each other a lot. She's actually in right now for a few weeks with her kids, and it's excellent.
Oh, that's good. That's real good. So how about your mom? She must be proud having 3 kids. They're all so amazingly successful.
Yeah.
Such wonderful things in the world.
She's very happy.
Yeah.
Loves her 6 grandkids. My brother's got 2 boys, and Alana's got 2. I have 2, and so she's got 3 boys, 3 girls, and that's keeping her busy. And then her and my dad live in California for like 6 months out of the year. They love it out there, and it's keeping them young. They're having a good time.
Absolutely, absolutely. So, how about your band? You still play in the band, right?
Yep, a little less than we were a couple of years ago. Now I play every few months, and I love it. I've been very blessed to be around some awesome musicians that don't require a lot of practice. If we did, we probably would have stopped years ago. If you text messages, hey, we should play this, that, and this, I'll see you at the show, and maybe at practice the night before. That's it.
Well, with everything else you're doing, as we talked before we started here, I don't think you get much sleep. You're very busy.
I do not.
You have 2 daughters as well, and a wife, and I'm sure they keep you busy.
Yeah, my 14-year-old's going into high school this year. 11-year-old's going in 6th grade. Somehow or other, the 6th grader has more drama in her class than the 4th. But I have a wife who's very busy. She's the vice president of a product in a tech company that's doing great work. So we are a busy family. I think we got to do it now while we're.
You think any of your children will follow in your footsteps?
I don't know. Nora says she wants to be a lawyer, but we'll see. Not like me. I was like 7 years old and my father was a lawyer, and I said, I can't wait to be a lawyer. And that was it. I never had any other aspirations to do anything else, which is kind of silly. But I knew I would be a lawyer from the minute I kind of knew, what it all was. So I never looked back, but I don't think my daughters are quite like that. I'm sure there's a lot more I'll try to get into first.
Well, it's kind of nice when you know that you're kind of solid in what you're going for.
Yeah.
Well, this was really great, Jamie. So tell us how people can get in contact with you if you're looking to, get in touch.
Yeah. All right. Well, we are in Wilkes-Barre, right on the corner of Northampton and South Franklin Street. We have an office in Pittston. We have an office in Bloomsburg. Obviously, our website is probably the easiest way to figure out what the phone numbers are and the emails are and the submissions are and whatnot. Facebook, we have a pretty good social media presence. You could always, message us on that. And that's really it. It's pretty simple these days. I mean, the name, you can find out anybody or how to get in contact with anybody.
Absolutely.
Yeah, we talked a lot about nursing home work today and medical malpractice, which we do a lot of, but we also do a lot of truck work and products liability and automobile crashes. And I'll tell you this, and I'll leave you with this. The thing we really pride ourselves in is seeing cases through beyond the courtroom and beyond a settlement. It's like all the hard work goes into getting the case resolved. And I think sometimes in our practice, it's over at that point. Some people will say, I got you, the settlement, I got the verdict, I'm done. And I think we as lawyers have an obligation that's much greater than that. And I think when you have the rare opportunity, I'm not saying with every case, but when you have the rare opportunities where someone has been left with horrible catastrophic injuries, and you've done all the hard work to get them a sizable sum of money, I think it's on you a little to see that through with them. Make sure they make the right financial decisions. Make sure you could help them build a house that's proper for them. We have a lot of connections locally and throughout the state, and you have rare opportunities sometimes to literally put somebody's life back together after your case is done, and you should use them. You should use that power that you have in the rare case to really truly put somebody's life back to the best you're able to. You can never make it the way it was before the incident, but get them back to the new normal the best you can. And don't just say, all right, here's your check. Have a nice life. I'll see you later.
Good
I think
luck.
that's a bad
Yeah.
mistake.
Yeah.
So anyway, that's kind of what I'll leave you with. And thank you very much for having me.
So thank you again, Jamie. I'm sure our listeners are going to absolutely love this conversation. And thank you for being on the show.
Thanks,
And
Tracy.
so that brings us to the end of our episode, and we will see everyone on the next.
See you guys.